My Lord, in this matter I appear with Mr. Edward Stewart, Appellants, and my Lords can see that Mr. Tatton and Miss Turner and Mr. Lunt appear for the respective respondents. Your Lordships are familiar with this area of law generally, having sat in this Constitution in an earlier case considering this matter, and at least one of my lords is very familiar with this area. I therefore propose to take some of the points relatively briskly and point to places in the authorities where we say our propositions are supported, rather than going into all of them in great detail and in some cases summarising points from other cases, if that's a convenient course for my lords. What I propose to do this morning is to address you on two broad heads which arise in this appeal. First, on the law as it has developed, both before and since Warner-Lambert, and how in our submission it should be applied to a case of this kind, which is a new pharmaceutical product case or set of claims. Secondly, the way in which we say erroneously the judge approached the disclosure of the patent and the specification in this case. There is a further issue relating to the respondent's notice. The court hasn't given us permission to file a skeleton in response to Mr. Turner's argument for Teva on the respondent's notice. Sandoz does not, as we understand it, join in that argument, but we will respond to those points orally to the extent that they are maintained, if that's a convenient course for my lords. Can I, before turning to the first group of submissions on the law, just make some preliminary remarks, as we did in our skeleton, on the patent in this case?
Yes. Before you do that, can we just deal with a couple of small points of housekeeping?
Yes, of course.
First of all, we are grateful for the amended grounds of appeal which have been filed in accordance with my direction. Have you established with the respondents whether there's any objection to those amendments?
No objection has been notified to us, so if there is one, then we'd be hearing it for the first time now.
Any objection?
Can I just make some observations about it, my lord, because I think it may help to clarify where things stand.
Yes.
They're in core bundle tab 2. And what's happened is, as you will see, is that a new ground 1A has been added with 4 paragraphs to it. Now, my lords, we had understood the appellants from their skeleton argument to be saying that the test in Warner-Lambert does not apply to product claims, and that it was enough in such cases to give an indication of a potential medical use which the skilled person has no reason to doubt, and that, for example, is paragraph 14 of their skeleton.
Yeah.
Now, their ground 1A does not actually say that, and in fact, there is no positive assertion in this new ground of appeal of the test they say should be applied. What instead they do is to say what the test should not be. And in particular, they say that it should not require explicit disclosure of experimental data. And in particular, in this case, they say it should not require explicit disclosure of a nanomolar Ki for apixaban. And one sees that, for example, just from looking at paragraph 1A of the new grounds. So we are confused about what the point is that they're now trying to raise. My lords, I would also point out that in any event, the judge did not, as they suggest, say that Warner-Lambert required experimental data, nor was that our position, and that's paragraph 40 of the judgment. Neither, of course, did he address the question of whether it was plausible from the application that apixaban had a nanomolar Ki, and that's because that's not a question he was asked to address. And we've made our submissions on that in our skeleton, my lords. So, my lord, insofar as this new ground 1A raises issues about plausibility of apixaban having a nanomolar Ki, we resist it being run just as we do when that point arises in the context of ground 2. But in that, so so far as it raises that, we already have that standing objection to that. Otherwise, our issue with this new ground 1A is simply that we don't understand it. Firstly, because it starts from an incorrect premise, namely that the judge said that the law required explicit experimental data, which he didn't. And secondly, because it doesn't match up with the way they have put things in their skeleton. And of course, in addition to that, my lord, we will, of course, be making forensic comments on the various changes of case that have been made by the appellants during the course of these proceedings. But those are our issues with the new grounds of appeal.
Yes, well, I understand everything you've said, little of which comes as any surprise to me. But can I be clear as to the bottom line? Because one needs to distinguish between two different things. First is whether the appellant should formally have permission to amend its grounds of appeal to introduce ground 1A. And secondly, whether as a matter of substantive procedural law, insofar as it is seeking to argue a new point not argued below,
yes,
it should be entitled to do that.
Yes.
Now, as I understand what you've said, and correct me if I've misunderstood, you're not objecting to the appellant having permission to amend its grounds to introduce 1A.
No.
But you'd maintain your objection to the raising of a new point,
Absolutely.
not argued below. And moreover, you say that actually it's not very clear what they're really trying to argue with this new ground.
That may emerge during the course of this morning, one hopes.
One hopes, yes.
So
All right.
I
Well,
thought I
that's
should make our position
all very clear. That leads me on, however, to this observation, and it may be that it doesn't really matter, but your point about the new argument on appeal, which is very clearly articulated in your skeleton argument, if I may say so, is one that is not free from authority, and yet none of the relevant authorities are cited anywhere. Now, it may be that that's because the principles to be applied are common ground, being fairly well known now. But if we are going to get into that question, and if there is any dispute as to the applicable principles, then we are going to have to look at the relevant authorities, which are not presently in the 3 volumes of authorities which we so far have. So that's just a little warning shot across both parties' bows going forward. Okay?
I'm grateful for that, my lord. No doubt there will be activity.
Thank you both. So, Mr. Alexander, I think that you will understand fairly clearly where we stand with regard to the amended grounds of appeal from that discussion.
Yes.
So you have your permission to make the amendment, and we'll get into the substance in due course. But before we go any further, the other housekeeping point I want to ask you about is this, and this is in a sense trivial, but I'm afraid it's caused me considerable distraction, and I'm sure there's a very simple explanation. But it relates to the form in which we have the judge's judgment. So, core bundle tab 9.
Yes.
And
Is that tab 9 or tab 8?
sorry, tab 8. I do apologise. Tab 8. I was misspeaking. I need to get the right page. Yes, if you turn to page 121 in the bundle, which is page 29 of the original judgment, paragraph 78, the judge introduces the agreed common general knowledge document as Annex A, and he refers, for example, to a passage at paragraph 77 to 121, and so on. When you turn, however, to Annex A, which starts at page 158 of the bundle, page 66 of the original, you find that it starts with paragraph 123.
Yes, I'm afraid, my lord, that confused me as well when I first came to this case. And I think it is an artifact of the fact that the statement of agreed common general knowledge also had other material before it, or at least the paragraph numbering was out for
Well,
one reason.
it's an artifact
or
of somebody
another.
using automatic paragraph numbering.
It could be as well, yes.
But I would find it of assistance if somebody could sort out what the correct numbering is, because it's not just in paragraph 78, because there are later cross-references to the document, and none of the paragraph numbering matches up. I mean,
Yes,
the judge quotes paragraphs by number, and they just don't match up, and it's an unnecessary exercise to try and track down which bit he's referring to.
My lord is right, and we will sort this out.
That would be
and
appreciated.
Give my lord an answer to it. I don't think it's completely an artifact of running on with automatic paragraph numbering, as sometimes these things are, because the annex starts at paragraph 123 and the judgment ends at paragraph 258.
No, it's not.
So
it's not done for that.
It's a more fundamental point than simply that one.
Anyway, I'll leave that there for now. But if somebody could tell us what the right numbering is at some stage, that
what
would
we
be
might want
appreciated.
to do is try and either get the original document to which the judge was referring with the right paragraph numberings that might be inserted.
Every version of the judgment that I've looked at is the same. If you look on Bailey, it's the same.
Yes. Yes, I'm not saying that there's another version in that sense. In any event, we will sort it out, and I do apologise for not having done that in advance.
I had the same problem, Mr. Alexander. I found that if you add 122 to all the references in the judge's judgment, it looks as if they probably get you to the right place. It's a slightly tedious thing to do.
Yes, that's why I suggested that it might be an artefact of the fact that there was something before that, before 122 in the statement. Anyway.
I'm sure the judge meant to attach the document which we had provided to him, because he's just copied out, just attached it as an annex, so we'll find out what we sent to him. And I think even in the draft judgment, it may have been right. Something odd happened between the draft and the...
All right, thank you.
Your document would have started at paragraph 1. That's why my lord adds 122 and gets the right answer, I think.
I'm sure that's right. We'll find the right document.
Thank you.
Yes, we can, however, see how very annoying that must have been. The only mitigation is that it's probably not necessary to refer to a great deal of material in that annex for the purposes of this appeal, and neither side really does that, because that was agreed common general knowledge.
Yeah.
So with those preliminaries, and I hope that insofar as there is any lack of clarity in the amended grounds, I can explain our position as we go along in the appeal, and also deal with the point on where it said that a new point is being raised now, which wasn't one below. That isn't a good point for reasons that I will explain, but it's probably easier to do it when that point arises. Because it's not a complex point, but it's one that's specific to the facts. So coming back to the our proposed order of play, we outlined some preliminaries on the patent before getting into the law, and part of the reason for doing that is so that your lordships have that in mind for the purposes of what might be called the core fact-sensitive part of this appeal. But it is also because it is useful to have that in mind in looking at the way in which the case law has developed in other contexts. Because as my lords will have appreciated from your either toes into this water or full body immersion in other contexts, the way in which the case law has developed within the United Kingdom, and probably more so in the EPO, is by application of sometimes quite generally formulated principles to rather specific factual situations of given patents. And it's quite important to have what the factual context was in mind of those patents and the contrast of them when one is looking at the law. In some respects, and I say this as neutrally as possible, some of the statements that come from the EPO are a little bit like statements of the European Court of Justice, where you have a general statement, which is then, you need to look at the context in which that statement was made in order for the real life and effect of the statement to appear. So, turning to the patent in this case, we respectfully submit that there are a few points that should be borne in mind. First, that this patent, and here I will use the term patent to refer to the application interchangeably unless it's necessary to distinguish between the two, discloses and specifically claims apixaban as one of a number of individually disclosed compounds in Claim 8 of the application, and of course as the sole subject of Claim
yes,
1.
but there is a difference there, is there not? In the patent, we have a claim to apixaban itself alone.
Indeed.
We don't find that in the application. What we find in Claim 8, if I've understood correctly, is a claim to a list of compounds. I haven't counted them, but it looks to me as if there's 20 or 30.
Yes.
And of those 20 to 30 in the list, apixaban is one.
Yes, that's correct. But it is nonetheless, at least to that extent, specifically identified. It's not merely a markish claim. Apixaban was, of course, new and inventive at the priority date. It has, as we note, been of great therapeutic benefit.
Yes, can you just help me on that? I understand it to be common ground that it was new at the priority date. But I want to be clear that I've understood correctly why that's common ground, because apixaban is to be found in the prior art. So if I've understood correctly, it's what one might call technically novel, and I mean technically from a legal perspective. That is to say that you can't satisfy the legal test of lack of novelty of apixaban by reference to the W0131 prior art, because when you look at W0131, there's no individualized disclosure of apixaban, even though it is there. Have I understood correctly?
Yes, I think that summarises the position, at least in relation to novelty, correctly. We say that there was also nothing in 131 that pointed to apixaban specifically, although it was there in the sense in which, one might use the analogy of some of the case law, a leaf is in the forest, but it wasn't called out, and 131 was not, in the judge's findings, something that made apixaban obvious in the conventional sense of obviousness, leave aside agrevo obviousness for the time being. So we respectfully adopt my Lord's summary of the position, but it is a patent that is, at least to that extent, specifically, or we would say at least more specifically to apixaban than any of the prior art pointed to. And to that extent, we respectfully submit that the researchers at BMS, or DuPont as it was, made and disclosed a real technical contribution. It's a concrete contribution. It may be that it may be said the original claims were too broad, but the patent unquestionably contained a valuable core. Secondly, as the court will have appreciated, the patent discloses a full synthetic scheme for apixaban, states that it's been synthesized by the patentee in such an amount as would be noticed, would set it apart from the other compounds disclosed in the patent. I'll come back to that point specifically because it's an important part of our core fact, when I say fact-specific, specification-specific appeal. Specification highlights apixaban specifically by reference to the quantity made in a manner that the skilled person would notice. It doesn't hide apixaban away, bury it in some massive irrelevant material or put the reader off the scent. It's not a situation of a patentee having made this vast claim and then trying to assert some sort of peripheral part of it. By reference to the amount made, apixaban is by a large distance, and I'll show my lords quite how large a distance, the most prominent of the various analogues disclosed, and that is a significant matter to which I will return. It stands out in this patent. And it will be our submission that this disclosure was such that a skilled addressee could and reasonably would infer that it was regarded by BMS as sufficiently promising to be taken forward into further work, and that was an important part of the disclosure of the patent. Third, the patent explains apixaban's putative mechanism of action by way of factor 10A inhibition. That was in fact justified of apixaban. There's nothing in the patent to suggest that with respect to apixaban it is likely to be wrong. Fourth, the patent provides details of straightforward conventional tests to verify apixaban's potency and efficacy, including tests specifically of in vitro tests of potency by reference to molar quantities. The patent is, in our submission, not on its face a speculative or armchair invention. It appears to be the product of significant research work, real pharmaceutical work of a traditional kind, one might say, thinking about what compounds should be made, what analogues should be made, and obviously, as essentially the judge held, then testing them for their activity. And it is, in our submission, the kind of patent which we suggest that the patent system was actually designed to uphold. It fulfills what has been described in some of the case law as the patent bargain. It gives the world something genuinely valuable, discloses something genuinely valuable, highlights it in the document in question, and does so in exchange for obviously a time-limited monopoly. And our overall submission, and I'll come to it in greater detail when we say how the law should apply to this, is that this is the kind of patent that a rational system of patent law should treat as a situation where a patentee has made a contribution, a real technical contribution. And insofar as what one might say the law is moving, come on to G221 in due course, to perhaps dethrone plausibility to a degree and elevate a consideration of whether or not a patent has made a technical contribution, we submit that this is the kind of patent that really ought to be upheld. And that the generics argument don't really grapple with, at that point, they focus rather narrowly on a particular kind of plausibility and analysis, without stepping back more to look at the bigger picture of what contribution was actually made by this patent. We say that's, in substance, an issue that the judge accepted, and we say he was not right to do so. So the generics then also seek to lump this patent in with those in which some very broad class is disclosed, and it's really left to others to work out what should be focused on. But this patent isn't like that. It not only highlights the specific analogue on which a notional skill team, we would submit, would reasonably focus attention, but it connects it with a specific use, a specific therapeutic use, via a specific putative mode of action. And although some criticisms have been made of the way in which we formulated our revised grounds, essentially what the generic companies are saying in this case is that despite this, it is insufficient because it doesn't contain data showing specifically nanomolar potency of apixaban, which at trial was shown to be what would have been thought necessary for therapy specifically. And that is their big point. And they say that this makes all the difference between a valid patent and an invalid one in this case.
Can I just ask a question about that? You refer there to the objection of insufficiency. The judge explains in judgment that it was common ground before him, this is paragraph 10.2, that the case was run by the respondents both as aggrevo obviousness and insufficiency, and that it was common ground before him that it made no difference through which prism one viewed the matter, because the test was the same under either head. And that explains why, as he says, he refers just to lack of plausibility, and why that is the terms in which his conclusion is expressed. Now, I haven't detected any, in the skeleton arguments, any attempt by either party to depart from that approach. Am I correct?
Yes, my lord, and there's a, in a sense, a fundamental reason for that, which is that this whole area of law, as my lord knows and will see in the cases, is really all directed to the same fundamental point, which is working out whether or not a patentee has actually made a technical contribution. And the way in which the case law has developed, because this analytically is something that could be seen under two separate heads, one of which is an insufficiency head, one of which is lack of inventive step head, and in fact there are others, because if one looks at HGS, the head under which the same kind of point was made was a lack of industrial applicability head. All of them are trying to get at the same point, which is that even though the, I'd say, statute doesn't provide for it, tribunals in various countries have recognized that there should be some way of limiting the grant of patents to the contribution that the patentee has actually made. And if the patentee has made no contribution at all, to find different ways of addressing that. Our big issue with the case and the judgment generally, as my lord will have appreciated, is that we say this is simply not a case where we have made no contribution. We can't be criticised for that. We made a contribution in the application and in the patent, and it's a contribution which should be of a kind that should be recognised by the law and shouldn't simply be said, well, you haven't made the right kind of contribution and your specification doesn't disclose data or doesn't disclose a particular structure-function relationship in this way, and therefore you lose. Our submission is that that approach is, which the judge took, is somewhat artificial. It's formalistic, and it doesn't actually engage with the contribution that was actually made. But that's a long way of answering my lord's point. But it's perhaps a more substantive way of answering it, because the way that the case law has developed in this area is to try and address that issue. Now, it is true that because of the way that the European Patent Office addresses claims of different kinds and issues of different kinds, they have addressed it in a somewhat different way. But that is the underlying point that we say comes out of aggrevo and is in fact all directed to reflecting a much more general point, which is to give effect to exon, that the contribution of a patent shouldn't, the monopoly of a patent shouldn't exceed the contribution that a patentee has actually made to the field. But the converse equally applies. The contribution of the patent should match. The claims of the patent should reasonably match the contribution that the patentee has actually made. And that's something that we say was just not reflected in the decision. So with that kind of introduction and an invitation to bear those points in mind on the patent, on the law, could I address you under three heads? First, the general point of where the law stands on the approach to the utility of plausibility in the context of pharmaceutical product patents. Our central submission on that is that it's important to allocate plausibility to its proper place in the analytic firmament. It's not a separate doctrine of law that's sort of applicable across the board. It's an instrument that can be used to identify, in some cases, whether or not a relevant contribution has been made. And one sees that from Agrivo, and indeed one sees that from Warner-Lambert itself. And I'll address that in greater detail. It's not one of these, a little bit like Pozzoli analysis, or it's not that the law requires Pozzoli analysis. The law requires you to look, see whether or not a patent is or is not obvious. Pozzoli may be a route to do that in the case of particular kinds of inventions. It's not a superadded aspect of the statute by reference to which inventions of this kind may always fall to be assessed. That's the first group of arguments. The second set of arguments relates to the role of verification testing and what part that may legitimately play in the law in this area. And we use the term verification testing because one of the points where we contend the judge fell into error was in treating BMS's argument as though it was submitting that what has been described as encouragement plus the ability to test was enough. That was the dividing line, essentially, in the Warner-Lambert case, where the trial judge and the Court of Appeal, in particular the Court of Appeal, took the view that there was, at least on one interpretation of what the Court of Appeal said, took the view there was sufficient encouragement to
yes,
test. And that was,
I don't think it was part of my reasoning.
No, and that's why I've slightly modified that.
But I agree, it was part of the Court of
But
Appeal.
it was part of the Court of Appeal's reasoning, and it was a part of the Court of Appeal's reasoning that was then criticised by the Supreme Court in Warner-Lambert.
Yeah.
And we respectfully submit that while one might, in some circumstances, legitimately criticise what might be called testing to discover an invention for the first time, there is a difference between that kind of testing, or the availability of that kind of testing, which one might say, almost picking up the language of Lord Sumption, highlights the fact that the patentee hasn't made the invention, he's kind of turning it over to the world to make the invention for the first time, and testing which is of a straightforward kind, which enables members of the public to test a claim that has been made by the patentee in a straightforward way, to test whether or not, in fact, the patentee prima facie made the invention, was correct in what they said. And we respectfully submit that there is nothing in Warner-Lambert that suggests that testing of that kind should be excluded when one is evaluating the ultimate question, namely what contribution has a patentee made. Because it might be said, well, all right, if a patentee only discloses in their specification that they have in fact done something from which it could be reasonably inferred that it is promising, but without disclosing the data upon which that is, that conclusion can be reached. But it is nonetheless very easy for a skilled person to just take that assertion and test it in this case, very easily done assay, which requires 30 minutes of incubation.
Yes, well,
then that is relevant.
This is going to be a core part of the argument on this appeal. I'm not expecting it to do it now, but at some stage you will need to explain to us a little more fully the nature of the distinction you've just drawn.
Yes.
Because, as you will appreciate, it might be said that from a scientific perspective, an absence of data is an absence of data.
Yes, and in a sense, I can't disagree with that point, my lord. The question is where it goes, because one of the things that we submit is clear in this area of law, whichever way you cut the Warner-Lambert cake or seek to apply it, is that data or experimental data is not always required in order for plausibility. And so the question then may be, well, is there enough in a patent to show that the patentee at least had the invention, so far as it sought to be claimed, in their possession? It's a rather general term. I didn't mean that in the rather specific term in which that's meant in other contexts, which would tell the skilled person, well, patentee seems to think this is good stuff. All I need to do is to test whether the patentee's proposition is correct. Now, it may be, and as it were tackling the point head on now, but we'll need to come back to it, that there isn't a great deal of linguistic footwork that one can do to sharpen up that distinction as a matter of language between verification testing and testing that is identifying the invention for the first time. That is something that one needs to look at how the principles are applied in the case law, to think how this should rationally apply in the case law. But in our submission, there is a natural distinction between the two, and it's a distinction which really was reflected in the approach that that divided the Supreme Court on this issue. So in any event, we respectfully submit that there's nothing in Warner-Lambert that rules out the role of verification testing. To the contrary, it suggests that it is appropriate. We would respectfully submit that if there is a scale of appropriateness, it is particularly appropriate in the case of pharmaceutical compound patents, where there is said to be at least a prima facie criterion of efficacy and potency, and where that can be tested with means either in the common general knowledge or, as here, identified in the patent. So that's the second set of submissions, and I'll come back to that, having looked at the passages where it's dealt with in Warner-Lambert. And the third point is whether, and if so, how the law of plausibility should be applied to give effect to the purposes for which the law was introduced. That is what might be called the patent bargain point. Now, in some senses, one might say that's analytically anterior to the other points. But the reason for dealing with it last as a set of arguments is because our point on the judgment is that this was an area where the judge didn't really step back and ask the question, which ought to have been asked right at the outset, namely, is this application of the law of plausibility really tackling the purpose for which this judge-made set of judge-made principles was introduced, namely, to get rid of speculative or what are called armchair inventions, or inventions where the patentee really has made no contribution and has left all of the substantial work in identifying the invention to others. So let me turn to the first point on second medical use and pharmaceutical compound claims. The judgments in Warner-Lambert, which we will come to shortly, both make the, or all make the point that there is a fundamental difference between pharmaceutical product claims and second medical use claims. The central point being, of course, that in relation to second medical use claims, the product in question is old and or not inventive. And the only contribution of the patentee can lie in having identified a new use for those claims. In contrast, in the case of new and inventive pharmaceutical claims, there are a number of contributions that are made potentially by the patentee, including the identification and manufacture, and in some cases route of manufacture, of the new chemical entity in the first place, regardless of the specific utility for which it is identified. Identification of potential utilities for the product in question, all of which are genuine technical contributions. Now, it might be said that in some cases, at the kind of extreme end, there are claims which one might characterize as armchair claims or no industrial applicability claims, where someone comes up with a whole list of products with no apparent use, or where the use that is identified is so general that it really has no credibility at all that the products are of utility of any kind. And it may be that in that rather limited terrain, this area of law is of utility in dealing with that kind of claim. And one sees, to some extent, that was what the Agrevo case was about. It was trying to deal with an excess claim to a particular part of the claim that the patentee refused to give in on, essentially, or refused to give up, where it was an entirely speculative claim, and the European Patent Office said, we're not having that.
That seems to be referring to what, to my mind, at the moment is a different distinction. So you've drawn a distinction, which I understand, between, on the one hand, a second medical use claim, wherein the only novelty is the use, and on the other hand, a new pharmaceutical product claim. That is very clear. But you have just referred to what seems to me to be a different distinction, which is a distinction between a claim to one compound and a claim to a class of compounds. Now, to what extent are you submitting that that's a material distinction for our purposes?
It is a material distinction, or, well, perhaps I can explain the materiality of the distinction once we've looked at Agrevo and what it is and is not doing, because it will be our submission that this area of law, insofar as you can assimilate insufficiency and Agrevo lack of inventiveness, is really there to deal with the situation where there is what might be called covetous claiming in relation to a terrain of class where there is really no credible basis for supposing that it has any real utility for the claimed purposes. But my lord is right, of course, to pick me up on the fact that there are two different dimensions here. There is the class versus non-class point, and then the second medical use versus product point. Can I take this up in Warner-Lambert, and which you will find in tab 22 of Joint Authorities 2. And I will refer primarily, obviously, to the decision of the judgment of Lord Sumption. There is one aspect where the analysis of some of the case law in the judgment of Lord Mance is of systems, and the approach that Lord Mance articulates is and recommends, obviously, as a minority, it is one that we will be looking at to see whether that approach is an approach that at least potentially has appeal in relation to product claims as opposed to the second medical use claims. But taking it up with Lord Sumption first of all, right at the outset of the decision in paragraph 1, what is made clear is that the proceedings raise, for the first time in these courts, questions of how the concepts of sufficiency and infringement are to be applied to a patent relating to a specified medical use of a known pharmaceutical compound. And he makes the point that patent protection for second medical use patents is difficult to accommodate within the traditional scheme of patent law. And it points out that two well-known obstacles, the process by which it was prepared were known, and the use for the new therapeutic purpose was not itself patentable because of the bar on patenting of methods of treatment. And he explains the way in which that circle was squared in the Swiss form claims approach. But it's important to have that in mind as the backdrop to the analysis that he then brings to bear of what is required in terms of patents of this kind. That point is in our submission reinforced by paragraph 3 of the decision, where he says that the development responded to a real problem, namely the difficulty of obtaining patent protection for second uses that may have been truly inventive and involved costly research, but it has given rise to formidable analytic problems as a result of the need to apply to Swiss form patents a statutory scheme which was not designed to accommodate them. And they have been mentions that they were regarded by some with suspicion, and articulates the history of the development of those claims to EPC 2000 claims. It's not a matter that we need to go into in this context. Before coming back to the law, just so that my lords who may not be quite as intimately familiar with the factual context and detail of Warner Lambert, which is quite important to understand what Lord Sumption was getting at, and the other subjects the other judges were getting at in their observations. It's perhaps useful just to have the facts in mind. Would it be of any utility if I just very briefly summarised where the way in which that developed? So that's dealt with really in paragraphs 4 onwards, and I'll try and summarise it as briefly as I can. The real substance can be taken from paragraph 5 on page 102 of the report 843 in the bundle, where he sets out the claims that were in issue in that case. The first claim was the use of pregabalin, that's the chemical name or pharmaceutically acceptable salt for the preparation of a pharmaceutical composition for treating pain. So pain was the broad category in the broadest one of those claims. The second claim was use according to claim 1 where the pain was inflammatory pain. And the third was use according to claim 1 where the pain is neuropathic pain. And inflammatory pain, just so that my lords have it in mind, was not a claim that was attacked on the basis of its implausibility. It was accepted that there was sufficient material in the specification rendering it plausible under the relevant standard to be used for inflammatory pain.
There was, in fact, experimental data to support it.
There was experimental data to support that in the patent. But the real terrain of dispute lay in claim 3. And claim 3 itself was then the subject of some analysis, both by my Lord Justice Arnold and the Court of Appeal and the Supreme Court, because the problem with claim 3, or one of the problems with claim 3, is that neuropathic pain itself covers more than one kind of pain. So you have this situation where you've got broad pain, inflammatory pain was all right, and then neuropathic pain, where essentially there were two kinds of neuropathic pain in question, and the decisions of the courts below accepted that one kind neuropathic pain was adequately or sufficiently rendered plausible, albeit the other was not. The patentee then said, oh, I want to amend down to the one that you've allowed me to have, and the lower courts upheld by the Supreme Court said, you can't do that at this stage of the case. You've had your chance to amend down and you can't do it. But the Supreme Court's decision was more fundamental than that with respect to Claim 3, because in relation to one of the kinds of pain, for which there was no experimental data in the patent, Lord Sumption's approach was to say, well, you can't have either of the kinds. We can't have a claim to either of the kinds of neuropathic pain because that's not sufficient. And that was the divide, really, between the members of the court on that key issue. And the crunch point of the divide was, well, what standard does the specification have to reach in the context of a Swiss form claim of this kind, namely a use for a particular therapy, in order for such a claim, whether it be a subclass of pain or a subclass of neuropathic pain, to be sufficiently enabled, subject to revocation for not complying with plausibility. And that is why, just to skip on slightly more rapidly, there were questions of interpretation of the claim, whether it was right as a matter of principle to do what was described rather disparagingly by the patentee as salami slicing of the claim into different forms of pain, different forms of neuropathic pain, and saying, well, because you can't have this form of neuropathic pain, your claim is out, and the issues on amendment that I have identified. But coming back to the core points on law, we can take it up at paragraph 17 of the Law Sumption's judgment. This is the point where he deals with the fundamental principles relating to the law of sufficiency and plausibility. And I would respectfully remind my lords of the reminding that Lord Sumption did about the purpose of this area. He said this: elementary as it is, it's worth reminding oneself at the outset of the juridical basis on which patents are granted, sometimes called the patent bargain. The inventor obtains a monopoly in return for disclosing the invention dedicated to the public for use after the monopoly has expired. And there's a reference to Lord Mansfield, and critically, the key, as it were, fons et origo of the doctrine, indeed all of the doctrines in this area, is Exxon fuel oils, referred to on the following page, where Lord Sumption cites the key part of the Technical Board of Appeals observation in that area. General legal principle is that the extent of the patent monopoly as defined by the claims should correspond to the technical contribution to the art in order for it to be supported or justified. This means that the definitions in the claims should essentially correspond to the scope of the invention as disclosed in the description. Although the requirements of Article 83 and 84 are directed to different parts of that application, since Article 83, which just to remind my lords is the insufficiency part of the EPC, relates to the disclosure of the invention, whilst Article 84 deals with the definition of the invention by the claims, underlying purpose of the requirement is support by the description insofar as its substantive aspect is concerned, and if the requirement of sufficient disclosure is the same, namely to ensure that the patent monopoly should be justified by the actual technical contribution to the art. That is the ultimate direction of travel of this whole area of law. And as Lord Sumption points out, the principal conditions of validity, novelty, inventive step, industrial application, and sufficiency are all, in one way or another, directed to satisfying the principle thus expressed. And if I may just jump ahead briefly on this point, the Supreme Court was making the point that even though one can apply different labels to some of these legal concepts, the destination of travel, the direction of travel of the law is the same in each case. So in paragraph 25, he says in relation to the law on, when he's looked at some of the principles from the EPO, English law diverges from this approach, although the divergence is more a question of labels than of substance. It distinguishes between so-called classical insufficiency, where the skilled person is unable to perform the invention or information disclosed in the specification, and so-called biogen insufficiency, where the claim is too broad because it exceeds the disclosed contribution to the art. And he explains that different legal systems essentially deal with the underlying object, or the exon object, I would call it that, in somewhat different ways, but they're all trying to hit the same broad target. And we respectfully submit that is something that my lords should bear in mind in this appeal, because what one doesn't want to do is to have what might be called a situation where a doctrine, which is a good servant of a underlying principle, turn then into a master without reference to the purpose of the principle. In that case, we say that's really what's happened with the law of sufficiency, at least the law of plausibility as applied in this case. Yes, plausibility may be a good instrument for analysing whether or not the exon bargain is satisfied. In some cases, it is not the sine qua non in every case, and in particular, it is not the sine qua non of analysing whether or not there's been a technical contribution and whether the patent monopoly is justified by the technical contribution in every case, including every pharmaceutical product case. So picking it up, just going back to paragraph 19 of the judgment, Lord Sumption refers to Lord Mance's observation that sufficiency is a rule of judge-made law, and takes slight issue with it, saying it would be more exact, so it's a statutory rule, which is fundamental to the public interest that justifies the issue of the patent. Contribution of judges has been to work out principles on which it can be applied to Swiss form patents. And Section 14 of the Patents Act and the corresponding provisions assume that an invention will be sufficiently disclosed, the specification enables it to be performed. In the case of a patent for a new product or process, that assumption is almost always correct. And it's important just to pause there. What one is dealing with in the case of a patent for a new product or process, in terms of the performance of the invention, what one is concerned with is whether or not the product can be made, whether it can be used, or in the case of a process, whether the process can be undertaken and there are sufficient directions in the specification to undertake the process, whether it be for manufacture or whatever, of a product that enable the process to effectively produce the product that is the object of the production of a process. And he goes on to say, the skilled person will discover that it works by replicating it in accordance with the specification. But the assumption is not correct in the case of a second use patent. The invention is not the compound or the process of its manufacture. The skilled person already knows how to make the product from the prior art disclosed in the original patent. So this is, in our submission, support for the point of the fundamental distinction that there is between, on the one hand, first medical use, pharmaceutical patents, and second medical use patents. The invention consists in the new purpose for which the product is to be manufactured. If, as section 14.3 and 72.1c are read literally and as an exhaustive statement of the requirement of sufficiency, all that needs to be disclosed is the new purpose, which is enough to enable it to be administered to a patient suffering from a relevant condition. The skilled person does not need to know how or why the invention works in order to replicate it. The result would be that the knowledge which made the identification of the new purpose invented need not be disclosed at all. And in our respectful submission, whatever one thinks of the approach to second medical use patents, one can understand why the approach is of such force in relation to second medical use patents, because one is dealing there with a patent where the purpose of it and the application is absolutely critical to there being an invention made by the patentee at all. And so Lord Sumption goes on to say the main problem about this result is it would enable a patent to be obtained on a wholly speculative basis. So here again, a point that reinforces my submission, my respectful submission, that what the law is there to do in this context specifically is to reject patents that are obtained on a wholly speculative basis. Without some disclosure of how or why the known product can be expected to work in the new application, it would be possible to patent the manufacture of known compounds for the purpose of treating every conceivable relevant condition without having invented anything at all. And so what's contemplated here is that a patentee could basically write down a whole list of old compounds, compounds invented by someone else, who someone else had disclosed how to make them. Someone else had disclosed potentially another use. And say, well, I'm just going to write this down, and because you can make the product, indeed because someone else has told you how to make the product, and I can then refer back to their work, you can essentially piggyback on the work of others without having done any work at all of your own. And that is why, one might say, was the underlying reason why the Supreme Court was concerned particularly about second medical use patents of this kind, and it is expressed very well, much better than I can in this paragraph. And so Lord Sumption goes on to say, it would be possible to patent manufacture of known compounds for the purpose of treating every conceivable relevant condition without having invented anything at all, in the hope that trial and error might in due course show that the product was efficacious in treating at least some of them. For that reason, both Mr. Justice Arnold and the Court of Appeal concluded that it was not enough simply to refer to a known compound and assert that it was efficacious for a specified condition. The patentee must disclose some reason for regarding this assertion as plausible. In their view, the requirement was not exacting, and then the Court of Appeal's formulation is set out. And Warner Lambert then submitted that even that undemanding test is an impermissible addition to the text of the Patents Act in the context of second medical use patents, and that was a proposition that wasn't accepted in paragraph 21 of the judgment. But in my respectful submission, that is not to say that the approach in Warner Lambert is then to be taken to be applicable across the board to all inventions, not even potentially only pharmaceutical inventions, which then requires evidence or some basis, come back to the scope of that, for sufficiency. And the Court of Appeal's approach there was to say that the claims will easily be seen not to be speculative where the inventor provides a reasonably credible theory as to why the invention will or might work. Same is true where the data in the specification is such that the reader is encouraged to try the invention. And so the dividing line there was between what we called encouragement to try and actually having done the invention and able to test whether or not the patentee had actually been truthfully saying that the invention worked. So if I can then come back to paragraph 23 of Warner Lambert, where Lord Sumption, in our submission entirely correctly, looks to what the underlying purpose was of the law of plausibility, where it actually came from and why it was being deployed, to determine whether it was right to deploy it in this context. And he says this: the concept of plausibility originates in the case law of the EPO as a response to overbroad claims, in particular claims to whole classes of chemical compounds, supported by a description which fails to show which compounds can be expected to work. So what there is being contemplated is that the law of plausibility isn't there to address chemical patents in general, What it is there to do, what it originated to do, was to deal with a situation where there were whole classes which were supported by a description which failed to show which compounds could be expected to work. And the Technical Board of Appeal treated the condition of sufficiency as satisfied if it's possible to work the invention across the scope of the claim from the invention and the information in the specification, interpreted in the light of the common general knowledge at the priority date. Addresses the broader question whether the disclosed contribution to the art is commensurate with the monopoly under the EPC Article 6 in the context of inventive step. And in that context, the case law requires the formulation of a problem which the claims of the patent could be said to solve, and imports a requirement the patent should not disclose just what the invention is and how to replicate it, but some reason for expecting that it will work. Plausibility was the standard to which the patentee was expected to demonstrate that. And the reference to agrevo, to which we will come in due course, is one where there was a class claim, and the class claim was essentially too broad, and the European Patent Office said, well, you can't have that, you can have a narrower class, but you're not prepared to narrow down, so your patent is dead. And then Lord Hoffman refers to Johns Hopkins, and it is worth just marking that, just to note what was said in that case. Any evidence support contention was that it was the patent there was whether a claim polynucleotide was a member of the TGFB superfamily was material published after the priority date, and the patent was held invalid for want of inventive step. And the board was observing that definition of invention as being a contribution to the art. Essentially what the board was saying was that you've got to have done something in order to justify your patent monopoly. What you can't do is come along and say, well, I'm just setting a research program to the rest of the industry without identifying or making any particular link between chemical, let alone specific chemical, disease and therapy or other purpose. And the way they put it was that the definition of the invention involved solving a technical problem and not merely putting forward one. And the tool for determining whether or not that was satisfied is that it's at least made plausible by the disclosure in the application that its teaching solves indeed the problem it purports to solve. Therefore, even if supplementary post-published evidence may in proper circumstances also be taken into consideration, it may not serve as the sole basis to establish that the application solves indeed the problem that it purports to solve. And just pausing there.
So, just before you go on, as Lord Sumption recites, that was to a single claimed polynucleotide.
Yes.
So it was neither a broad class of compounds nor a second medical use case.
No, and I accept that. And my submission is not that there are no situations in the context of pharmaceutical patents where a plausibility analysis will be appropriate. My point is a somewhat more modest one, which is that it is not right to say that a plausibility analysis is required in every case of a pharmaceutical product claim. In particular, where it is possible to see from the specification and the material provided that the patentee has made a genuine contribution, in particular with respect to that specific identified analog.
Sorry, I'm sure it's my fault, but I'm struggling to understand that submission. So, as I understand what you just said, you say that if you have a claim to a single pharmaceutical product, sometimes it is appropriate to test it for plausibility, and sometimes not.
It may be in certain circumstances that one cannot rule out plausibility as being a way in to determine whether or not the patent taken as a whole has made a relevant technical contribution. But what we respectfully do resist is the idea that a plausibility analysis is required in relation to every pharmaceutical compound patent, regardless of what else is said in the specification, which is the approach that we detect is recommended by the generics.
One starts always, of course, with the claims. So one has 2 patents, each of which contains a claim to a single pharmaceutical product. How does one know whether to apply the plausibility test or not on your submission, given that you seem to be saying that it applies to some such claims but not to other such claims?
Well, one of the ways of doing it is to look at the specification and see whether there is material in the specification from which one can conclude that the patent is not actually a speculative patent at all, that it has identified relevant pharmaceutical, a relevant pharmaceutical analog or analogues. What is not necessary after that is then to apply a plausibility analysis superadded to that analysis.
I'm struggling to understand that, because as I understand what you've just said, and please correct me if I'm misunderstanding, that seems to be a submission not that plausibility is sometimes never to be applied, but in other cases is to be applied. Rather, the submission is that when you apply the test of plausibility to a claim to a single pharmaceutical product, sometimes it may be satisfied and sometimes it may not be, depending upon the disclosure in the specification. And if that's the submission, I don't think Mr. Tappan would disagree with you.
No, you're right. That is obviously part of my submission, and part of my submission on the other aspects of the case is that one's got to then apply whatever plausibility test there is in the appropriate way, and that's not something that we say that the judge did. But our point is actually, at least the first point, is a preliminary point to that, which is that it's not in our submission necessary in every case of a pharmaceutical product to apply a plausibility analysis.
Can you tell me what criterion are you putting forward which enables the court to know whether to apply plausibility or not to a single pharmaceutical product claim, given that you accept that in some cases it is appropriate to do so?
Yes. So it's perhaps not easy to articulate those criteria in a kind of micro way. But what we would submit is, if looking at the specification as a whole, the court can reasonably conclude that the invention in question is not a speculative invention, that there is no prima facie reason for supposing that a claim to efficacy, whether it be pharmaceutical or other efficacy, is wrong. In those circumstances, one doesn't need to have additional material in the specification to demonstrate that that claim is, in fact, correct. The dividing line, as we submit, between the judges in Warner-Lambert was a suggestion that there needs essentially to be positive proof of some kind or another in the specification, even in relation to a non-second medical use claim, in circumstances where there is no reason to doubt that the claim is made for efficacy is prima facie a credible one. And we respectfully submit that that is not required. Now, the reason for having some difficulty in articulating the precise boundary between those two is actually the same reason why articulating the precise boundary between the decisions of the judges in Warner-Lambert is not always that straightforward, because one looks at things either in a positive way, no grounds for supposing that the invention would not work, positive grounds for supposing that an invention would work. In any given case, the distinction between those two may be quite hard to draw, and one sees that there was a division, essentially, between very experienced judges on that issue.
The dividing line you seem to have just drawn is between what is referred to as ab initio plausibility and ab initio implausibility. And yet the enlarged board has just told us that there is no such distinction.
Oh, I'm coming on to that. In fact, the enlarged board, we would submit, has, in some sense, has gone further than that, in that what they have sought to do is, as I put it earlier, demote the concept of plausibility from the throne with which it was supposed to occupy by the referring board. As the referring board, just to answer my Lord's point in slightly greater detail, was inviting the enlarged board to tell the world whether or not the law should be ab initio plausibility or ab initio implausibility. And as my Lord has picked up, the enlarged board declined that invitation. Indeed, the dispositif, if one can frame it in that way, did not use the term plausibility at all, albeit that was in a context of agrevo, equivalent of agrevo obviousness. But nothing suggests in that decision that the enlarged board, or the EPO in general, is saying you should apply a law of plausibility to every case. And the question for the courts is whether it should be ab initio plausibility or ab initio implausibility. The enlarged board has taken a completely different line in our submission on this. And we deploy that in support of our argument of saying, well, if that is the approach taken by the European Patent Office, it would be odd for the English court to say that in every case of a product patent, which has the different characteristics that I've articulated, the English court should nonetheless apply a doctrine of prima facie plausibility to determining whether or not that patent is valid or invalid.
But to be clear, I did not find in your supplemental skeleton argument any submission to the effect that as a result of the decision of the enlarged board of appeal of the European Patent Office in G221, this court is no longer bound by the decision of the Supreme Court in Warner-Lambert.
Oh, no, and that's not my submission at all. And forgive me if my Lord's taken that. I'm not saying that this court is not bound by the decision of the Supreme Court in Warner-Lambert. What I am saying is that the decision of the Supreme Court in Warner-Lambert should be confined to second medical use patents. And there is a good rationale for that, given in the decision of the Supreme Court itself, which draws the relevant distinction, that it is consistent with the approach taken by the European Patent Office, which is not to require a prima facie implausibility or still less prima facie plausibility test as a matter of generality in relation to all patents. And that's why...
All right, but I'm sorry to keep interrupting you, but I need to be clear as to where you're going, because you now seem to be giving an answer to the query raised by Mr. Tappin arising out of your amended grounds of appeal, because you've just made a very clear submission, which is Warner-Lambert doesn't apply.
To this...
End of. And yet that's not what your amended grounds of appeal say.
Well, the way in which we have framed our amended grounds of appeal is to tie them somewhat more closely to this case. But our proposition is...
I'm sorry, I don't think the question is a difficult one. On the one hand, you can submit that Warner-Lambert has no application to claims for single pharmaceutical that's very straightforward, and one can understand the basis for that case. On the other hand, you can accept that it does apply and then argue about how it applies to the individual case on the facts of that individual case. And all I'm trying to do is to ascertain which of those two positions you are adopting. The reason being that the skeleton argument appeared to adopt the first of those two positions, hence the invitation to amend your grounds of appeal. The amended grounds of appeal, ground 1A, appears to adopt the second position, but you have just articulated a moment ago the first position. And I wish to be clear which of those two is your client's case.
I understand my Lord's confusion, and my apologies if that has created confusion. Our argument is in the alternative. First, Warner-Lambert does not have application to chemical entity patents, or at least does not have universal application in that a plausibility analysis is not required of every chemical entity patent. However, if the approach of Warner-Lambert applies, and for whatever reason, the approach applied is not as demanding with respect to this patent as the judge thought it was.
That's helpful, thank you.
And did I understand it correctly? When you say plausibility is not required in relation to every chemical entity patent, you draw a distinction between what can be seen to be a speculative claim and a non-speculative claim. And in a speculative claim, you might need some plausibility to stop the phenomenon of armchair speculation. But in a non-speculative claim, you say you don't.
That's right.
Yes. How does the person reading the patent, how does the court know whether, if the patentee says, here's a new chemical compound, it is effective, or there are reasons for thinking it is effective against X, whether that's just a thought experiment or whether that's based on something else?
Well, I mean, that is, my Lord's obviously put my Lord's finger on a key point as to how you distinguish between speculative patents and non-speculative patents. And the reason is actually it's not easy. And perhaps I can explain why it isn't easy and why my Lord's question is such a good one before coming on to answering it. The reason in this area is because there can be various ways in which invention is legitimately regarded as having been made in a non-speculative way. So let's give some examples. One way is empirically, going out to the world, making new compounds, testing them, and determining whether or not they are efficacious. But that's not the only way. Another way is what might be called analytically. So you could say, well, I think on the basis of my analysis of the chemical structure, it's likely to bind to a particular group here or there, and this is my rationale for thinking that that may be the case. There is also a third category, which probably doesn't really arise in the context of pharmaceutical claims in reality, which might be called mere inspiration inventions, where someone says, it came to me in a dream that the benzene ring was cyclic. I mean,
Which did come in.
Yeah, well, that's why I use that as an example.
Yes.
Yeah? Now, how does one put that into the framework of speculative or non-speculative? What one needs to do in my submission in this area, stepping back and thinking about this as an area of, in part, legal policy, is to think, well, we need to have a law that is sufficiently accommodating of the diversity of ways in which invention takes place, legitimately takes place, and advances are made, but which also then excludes people who are simply writing something down and claiming a lot of money for writing something down having done no work. So that's the nature of the problem that we're dealing with, which is actually a quite fundamental problem. Then one tries to address that problem. So, well, how am I going to now distinguish between Hercules' genuine genius and someone saying, oh, well, this cytokine, for example, is likely to is likely to be of general pharmaceutical utility, having no idea of whether or not it has any pharmaceutical utility, whatever. It is not an easy thing to do, but perhaps there are a number of indicia, at least, which a court can and should take account of in trying to see what side of a line of speculative and non-speculative a patent falls. And they may be this. Does the patent disclose prima facie a body of serious research work? Does it prima facie disclose the fact that not only have new pharmaceutical molecules been developed, but that they have also been tested? Is the claim for utility made of those pharmaceuticals inherently implausible, if I may put it like this, or inherently incredible? Is there a rationale provided, whether by way of specific mechanism of action or other, that a skilled person would reasonably think is a reasonable one, even if not a substantiated one, for considering that the invention has been made? And finally, linking it to the point about testing, is it possible for a notional skilled person using only common general knowledge or easy tests given in the patent to determine whether or not the patentee has simply been speculating in respect of the products in question, or whether they haven't? Because one might say that one of the touchstones of speculation and non-speculation is if you say, well, all right, I've got this specification which, let's say, claims a vast terrain, and it's a very difficult job of work to determine whether or not any given molecule has relevant characteristics and so forth, and that's accepted. One might say, well, that is actually indicative of its speculative nature, and one can put it the other way around. You might say, well, what is a speculative patent doing? Speculative patent is seeking to claim the work that has either been done by others previously, or serious work to be done by third parties. Now, if in fact what is required and only required by a third party is straightforward verification of what has been claimed, that is, in our respectful submission, reasonable evidence, put it as a matter of evidence, that what's disclosed in the patent is not speculative. Now, I am conscious of the fact that that is not giving my lord what might be called a purely analytic answer, in the sense of, right, I'm going to draw a line down the page and we've got a... But part of the reason for not giving my lord an analytic answer is the reason that I've given, that there is a diversity of situations for which the law genuinely has to cater in this kind of context, when it is trying to determine whether someone has exceeded the bounds of reasonable claiming. And in the pharmaceutical industry, it has to cater with the fact that people do traditional science. This might be regarded as a very traditional scientific approach, making a lot of chemicals by various synthetic schemes and testing them, by various forms of predictive, analytically predictive science, and other ways. And so in my submission, it's not quite a sort of elephant situation when you know it when you see it. But there are, the courts are not at sea in criteria or indicia that enable the court to consider which side of a line something falls upon. I'm conscious that that won't be a completely satisfactory answer for any of my lords, but it is an answer which is realistic within the context of what we're dealing with in this industry.
Thank you.
I think that's been a helpful explanation of your case, but I'm conscious of the fact that we've rather diverted you from where you were.
Yes.
Which was Lord Sumption's discussion of Johns Hopkins.
We have. I'll come back to that if I may now. I don't know whether my lords want to have a shorthand writer break, but if not, then let's just press on. So we were back at paragraph 25, which I've just drawn attention to previously, where what the court was doing was drawing attention to the fact that there was a commonality of principle here, even though it was expressed in somewhat different ways. And then on paragraph 26, the court there again was saying that the answer to this anomaly in the case of Swiss form patents was supplied by a series of decisions in which the Technical Court of Appeal held that there was to be implied into a purpose-limited claim an assertion of efficacy for the designated purpose, and that this was an intrinsic technical feature of the claim, and the proposition was started off with mobile friction-reducing additive by a plant growth regulating agent. It's a proposition that's been taken up by some of the English case law, as my lords are all aware of, that in some cases the evaluation of inventive step, it takes place by assuming that the target at which the case has to fire includes an element of efficacy for a given either condition or other purpose. But then Lord Newbery goes on Lord Sumption goes on in paragraph 27 to refer to Prendergast's application, which was a situation of a speculative invention, and there again, in relation to a Swiss type application, Mr. Justice Newbery, as he then was, said that the specification must include some basis for supposing the claimed therapeutic efficacy was true. In relation to a Swiss type application, it appears to me, in the absence of any practical evidence of the idea of working, that is the idea of using a well-established drug for the treatment of a condition for which it's not so far been used. Absence of any evidence of the idea of working involves the absence of a description, and there's obvious force in the contention where you have a claim for the use of a known active preparation of a medicament for the treatment of a particular condition. The specification must provide, by way of description, enough material to enable the relevantly skilled man to say that this medicament does not treat the condition alleged, and that pure assertion is insufficient. One's got to remember here, just because there's a reference to pure assertion in the judgment, that this was a situation of pure assertion. It's not even a Hercule dream situation. This was a really entirely speculative claim. And in paragraph 28, there is a reference to Salk, and I'll come on to that in slightly greater detail, because one thing that Salk recognises, as does some of the other case law, is that the requirements of plausibility, however and to whatever they apply, are not so stringent that they require a patentee to, as it were, have gone the whole way to show that a pharmaceutical is, let's call it, druggable. And just pausing there, so that my lords all understand that point, one of the difficulties in this area is that everyone knows that in order to get a working pharmaceutical at the end of the day, you've not only got to show that it's potent, you've also got to show that it's specific to the relevant condition, you've got to show that it's bioavailable, or it can be formulated in a form that's bioavailable available, that it's non-toxic, that there are a whole lot of conditions, obviously many of them regulatory conditions, that need to be applied in order to satisfy the requirements of an ultimate pharmaceutical. And the courts have recognised that, Salker in particular, by saying, well, look, we're not going to take a situation where we kind of expect the patentee to have gone the whole way down the route, down the path. And there is a real policy rationale for that, which is this. The patent system is designed to protect inventions that have been made at a relevant priority date. But of course, the pharmaceutical system, a lot of the work that needs to be done in order to satisfy the relevant regulatory requirements and actually show that a product can be made is inevitably done after a patent is filed for an initial molecule, because there is a lot of heavy work in that context. Now that again is not a perfectly analytic circle that one can square. If one were being completely logical, one might say, well, you know, patentee has got to have gone all the way to show this product is good for purpose. No one suggests that. What is suggested is that one has got to have, as it were, got the pointer right at the outset. And the reason that that is important is because then the patent, what the patent does, is protect the work that is done in developing the various inventions, but also actually realistically protect the approach to the industry. These patents don't take place in a complete vacuum. And so that's why that's a reasonable rationale. And it is a reason why we also say that what one ought not to do in a case of this kind is adopt, whether one's adopting plausibility or not, an approach that is unduly strict or formalistic in relation to the requirements of what a specification has to disclose in order for it to be regarded as sufficient. Specifications of this kind are, in some senses, starting points as much as ending points of a process of pharmaceutical research. And that is recognized, it is an accepted principle, and it is a sensible principle, and it is why the threshold should not be regarded as a high threshold. Now, it's true in the case of second medical use patents that you might say, well, actually there is a kind of justification for the threshold with respect to establishment of that use being somewhat higher. Because what you're doing there is you're taking an old pharmaceutical, and an old pharmaceutical that someone else may have had to do a lot of work on in establishing not only the first use, the first efficacy, but also the non-toxicity, the druggability, the et cetera, et cetera, et cetera. When someone comes along and says, I'm on a second medical use, they're in a sense piggybacking on the work that's been done, not only up to the patent, but also in a sense beyond the patent by the first patentee. And so one thinks about this in sort of broad policy terms. You say, well, what are we doing here? Should we allow speculation to dominate in second medical use claims? No, the reason why you might not want to do that is because that actually unfairly enables a second speculative comer to take the benefit of the work that's been done by the first comer in a number of ways without making a real contribution of their own to the research program. So if one adopts that approach, then one can sort of see the rationale of why, in the case of something like Warner-Lambert, one might want to set the bar for second medical use patents somewhat higher than one might want to set it for first medical use patents, for pharmaceutical patents. So that's an observation on Salk, and a policy point that my lords, should we respectfully submit, have in mind. And that's reflected in paragraph 29 of the judgment, and why, in that context, in vitro tests were regarded as okay. Over the page on 112 of the report, This means that the skilled person is made aware of the structure of the active ingredient proposed for the pharmaceutical compound, as well as in technical terms a definite link between the ingredient and the mechanism already involved in the disease state. The presence of a cause-effect relationship is thus made plausible. So that is, in our respectful submission, the right approach in respect of second medical use patents, and that is confirmed in the later approaches of the court. If I take it up in paragraph 36, just skipping for the time being the analysis of the case law in Ipsen, Allergan, and BMS at Assassinate. '36 and 37 are important paragraphs in relation to both the first point on the applicability of plausibility in the context of second medical use, but also on the assumption that the same approach applies to patents of this kind. And it is important to look at paragraph 37 in the context of paragraph 36. So if I can take it up there. Court of Appeal's statement of the effect of plausibility has already been quoted. They considered the threshold was not only low, but the test could be satisfied by a prediction based on the slimmest of evidence, or one based on material which was manifestly incomplete. Consistently with that approach, they considered the board's observations in Salk laid down no general principle, and Lord Sumption disagreed. Principle is that the specification must disclose some reason for supposing that the implied assertion of efficacy in the claim is true. But the court went on to say, plausibility is not a distinct condition of the validity with a life of its own, but a standard against which that must be demonstrated. Its adoption is a mitigation of the principle in favour of patentability, which reflects the practical difficulty demonstrating therapeutic efficacy to any higher standard at the stage when the patent application must in practice be made. The test is relatively undemanding, but it cannot be deprived of all meaning or reduced, as Lord Justice Floyd's statement does, to little more than a test of good faith. Indeed, if even the threshold were as low as he suggests, it would be unlikely to serve even the limited purpose that he assigns to it, barring speculative or non-shown claims. And then Lord Sumption sets out the key points to be borne in mind. And the content is influenced by the legal context. We would say, for reasons I've submitted already at length, that its content is also influenced by the factual context and the nature of the claims of which one is considering. First of all, that the proposition that a product is efficacious for the treatment of a given condition must be plausible. But it's not made plausible by a bare assertion to that effect, and the disclosure of a mere possibility that it will work is no better than a bare assertion. And what we submit the Supreme Court was getting at there was a kind of bare assertion that was simply backed up by nothing whatever. No testing that appeared to have been done, no making of the compounds or for testing them, and no suggestion from which it could be inferred from the patent taken as a whole that the patentee had made and tested the compounds and found that they had sufficient efficacy. Mere assertion here is in a sense, the disparaging term used of merely speculative patents. It's not a term that is properly applied in our submission to a patent which doesn't appear to be the fruit of mere assertion, but appears to be the fruit of real research work. It's true, of course, that as Lord Sumption points out, Connor and Angitech, it's hard to see how the notion that something is worth trying or might have some effect can be described as an invention in respect of which anyone would be entitled to a monopoly. So far, so good. But the position is we would respectfully submit different, where a patent says, well, I have tried this, I have tested it, and prima facie gives reasons which are not incredible to suppose that that is a successful outcome. Then third, the claimed therapeutic effect may well be rendered plausible by a specification showing that something was worth trying for a reason, i.e. not just because there was an abstract possibility that it would work, but because reasonable scientific grounds were disclosed for expecting that it might well work. Again, even in the context of a second medical use patent, this is not a demanding standard. It's not saying, well, you need to have shown either analytically or in this case by test results of a particular kind, that a given threshold is one that has been satisfied. The disclosure of those grounds marks the difference between a speculation and a contribution to the art. And again there, we say that the Supreme Court was highlighting that what the court is getting at is a difference between speculation and a contribution to the art, that what you're aiming for in this law is to determine whether or not the patentee has made a contribution to the art or whether they have not. And they reinforce, Lord Sumption reinforces that point by saying this is in substance what the Technical Board of Appeal has held in the context of Article 56 when addressing the sufficiency of disclosure made in sportive claims extending beyond the teaching of the patent. In my opinion, there's no reason to apply a lower standard of plausibility when the sufficiency of disclosure arises in the context of EPC Article 83 and 84 and that analogue in Section 14. In both contexts, the test has the same purpose. And what is that purpose? To determine whether the patentee has made a contribution to the art. And in this context, one has to bear in mind that the court is not here, as it were, evaluating the level or nature of the contribution to the art that the patentee has made. What it is determining is whether the patentee has made a contribution to the art or no contribution to the art with respect to the relevant part of the claim that one is concerned with. It's not there to say, oh, well, the patentee has made a dazzling contribution to the art in respect of this particular compound. That's one of the points of why the threshold is a modest one. So fourth, although the disclosure need not definitively prove the assertion that the product works for the designated purpose, it must be something that would cause the skilled person to think that there was a reasonable prospect that the assertion would prove to be true. Now, framed in that way, of course, it's a very general proposition. Something that would cause the skilled person to think that there was a reasonable prospect that the assertion would prove to be true. Our submission on this patent, as my lords will gather, is that there was something that would cause the skilled person to think that there was a reasonable prospect that the assertion would prove to be true. But if you take that approach and you say, well, there's got to be a very specific kind of thing or kind of things that would cause the skilled person to think that there was a reasonable prospect that the assertion would prove to be true, that's actually almost raising the bar beyond that, which even Lord Sumption recognised would be appropriate for second medical use patents, and that is in substance what we say the judge did in this case, and that he rejected the analytic basis and he rejected any evidence basis, but what he didn't do was step back and ask really realistically, well, is there something, is there something that there is, something that would cause the skilled person to think that there was a reasonable prospect that the assertion would prove to be true. Fifth, the reasonable prospect must be based on what the technical board in SALT called a direct effect on a metabolic mechanism specifically involved in disease, mechanism being either known from the prior art or demonstrated in the patent per se. Sixth, in SALT, the court point made in the context of experimental data, but the effect on the disease process need not necessarily be demonstrated by experimental data. It can be demonstrated by a priori reasoning, and that reflects the point that I've made. For example, let's name more than an example. Specification may point to some property of the product that would lead the skilled person to expect that it might well produce the chemical claimed therapeutic effect, or to some unifying principle that relates the product to the proposed use, something else which would suggest as much to the skilled person. Seventh, sufficiency is a characteristic of disclosure, and the matters must appear from the patent. We don't take issue with that. Disclosure may be supplemented or explained by the CGK, but it's not enough that the patentee can prove the product can reasonably be expected to work in the designated use if the skilled person would not derive that from the teaching of the patent. So if one takes that as the framework for application, and if, as we say the judge ought to have done, it's applied with the purpose in mind, namely to get rid of speculative claims and to give full weight to what the disclosures are of the specification. In some senses, we have no problem with that. The problem arises if one doesn't do that and one takes this as a kind of strict and higher hurdle that is applicable and appropriately applicable to second medical use patents. And they says, well, we've got this strict and high hurdle with respect to second medical use patents. We're now going to incorporate it into pharmaceutical product patents, and so you don't satisfy it because of a narrow failure to satisfy, in this particular context, experimental data or the analytic point. So in all respectful submission, that is obviously a helpful analysis in respect of second medical use patents, even insofar as it applies more broadly. It is something that needs to be applied, if I put it this way, realistically with respect to what is disclosed in the specification and having regard to the breadth of the concept in paragraph 37, which Lord Sumption was contemplating would be appropriate even for second medical use patents. So that is, in some senses, the two aspects of our argument, which are first, Warner Lambert does not apply more broadly than second medical use, but even if it does, the approach that one has to take with respect to it is a more, well, I've used the term realistic one, than the judge thought that it applied on the assumption that it applies across the board in exactly the same way. So can I then turn to the points on data from, or the use of data from Warner Lambert, which one can pick up at paragraph 40. Lord Sumption there was saying that the Warner Lambert's second argument reports below were wrongfully rejected later published data is relevant. Submission is also contrary to legal basis of particular head of insufficiency. Know that pregabalin works for the treatment of both peripheral and central neuropathic pain because, like any other medicament on the market, it underwent demanding clinical trials and so forth. The question is not whether it works, but whether the contribution to the art consisting in the discovery that it can be expected to work has been sufficiently disclosed in the patent. The inherent difficulty of demonstrating this before clinical trials is taken into account in the modest standard, which is, i.e. plausibility, which is applied to test it. And then that's the point that was made by the Technical Board of Appeal in Salk, at paragraph 8, to which I've already drawn my Lord's attention, and it's that paragraph that's the key paragraph in Salk on that point. But again there, as my Lords will notice, the general principle that the extent of the monopoly conferred by the patent should correspond to and be justified by the technical contribution to the art has to be kept in mind. We respectfully submit that what that is saying is you do need to bear in mind the purpose of the law in this area, which is to ensure that technical contribution is properly reflected. But then Lord Sumption goes on to say this. Doesn't mean that subsequent data is never admissible in a dispute about sufficiency, but the purpose which it's admitted is strictly limited. Where the asserted therapeutic effect is plausible in light of the disclosure in the patent, subsequent data may sometimes be admissible either to confirm that or else to refute a challenger's contention that it does not actually work. And then there's a reference to quite a bit of case law on that, to which we do not need to go. But it cannot be a substitute for sufficient disclosure in the specification. As the EPA Technical Board of Appeal observed in Johns Hopkins, it cannot be a substitute, it makes the point, can't be a substitute for sufficient disclosure in the specification. That point was picked up again in paragraph 53, where, as I've mentioned before, the Court of Lord Sumption analysed the Court of Appeal's use of the availability of tests to confirm, or in that case, not confirm, but devise an invention for the first time. And it's useful just to bear those points in mind on the facts of that case. Lord Justice Floyd said that he was fortified in his conclusion by further consideration which the judge had not relied on, namely that it was established that the evidence that the skilled team would be encouraged by the data in the patent to carry out simple tests which are themselves identified in the patent to confirm the suitability of pregabalin for peripheral neuropathic pain. I would have thought on the basis of that evidence, as I think the judge did, the specification thereby made the contribution to the argument would justify a claim to peripheral neuropathic pain. Simple tests that Lord Justice Floyd were referring to were the Bennett and the Kim and Chung tests for peripheral neuropathic pain. The evidence that he had in mind was that of Dr. Scadding. Dr. Scadding had accepted that the skilled person would be encouraged by the data in the patent to ask the neuroscientist to test pregabalin for neuropathic pain. But, and this is an important part of the context, and Professor Wood, the expert neuroscientist called by Octavius and Mylan, who would notionally have been asked to carry out these tests, gave more guarded answers. The evidence in summary was that there were no data whatever about neuropathic pain in the patent, that he would be encouraged by the broad terms of the patent to try many tests, including the Bennett and Kim and Chung tests, where he said many different pain mechanisms that can give apparently similar symptoms, which there were different models and it would be necessary to test for all of them. Some were difficult to test for. It was put to him even that Bennett and Kim and Chung tests would not provide definitive proof of efficacy because it was a step-by-step process, and then there are various answers given, and the upshot of those answers, as my lords can see, is in the second question and answer. Certainly inspire you to analyse its activity in a broad range of pain models. Of course, this would be useful for the clinician attempting to exploit the drug in treating various different types of human pain. Animal models are not ideal, but they're always a useful pointer for the clinician, a useful starting point, absolutely. And the answer, I should have actually referred to the question that was asked earlier. The question that was asked by the questioner was, the data in fact would give you sufficient motivation to carry out further tests, and step by step you'd reach a stage where you have demonstrated that pregabalin was efficient for the treatment of pain. So what was contemplated there was essentially evidence that because you could, as it were, have a research program, the patent said a research program, which would be an attractive research program for a scientist to undertake, and that the research program would eventually, if one fulfilled it, reach a conclusion that neuropathic pain was indeed treated by pregabalin. That was sufficient. And Lord Sumption was unable to accept that. And he picks that point up by explaining that first of all, and then says this. In cases like this one, where the invention is novel, but the objection of insufficiency is that the claim exceeds the disclosed contribution to the art, the role of hypothetical simple tests is necessarily more limited. As the EPA Technical Board of Appeal observed in Johns Hopkins, specification can be said to contribute to the art if it solves a problem, but not if it merely poses one. Or, as Lord Hoffman observed in a passage I've already quoted, the notion that something is worth trying cannot be enough without more to justify a monopoly. Specification in the present case says nothing about neuropathic pain of any kind. It says nothing about central sensitization, which is said to provide a link between neuropathic and inflammatory pain. The mere fact that the skill team faced with an apparent discrepancy between the breadth of the claims and the absence of supporting data in the specification would be encouraged to fill the gap by carrying out tests of its own, serves only to confirm the absence of any disclosed contribution to the art. That is the rationale of the rejection of the utility of tests in Warner-Lambert. The judge, Lord Sumption was saying there, essentially this patent, insofar as it relates to neuropathic or peripheral neuropathic pain, is setting a research program. It's not saying, we have solved this, we have made it. There is reason to believe that this works, or one could infer that it works from this material. It is actually go off and try for yourself. And one of the reasons why, just thinking about the facts of that case, that is an unattractive proposition in that context, is because it was common ground that these pain conditions were really rather different. For example, you couldn't draw any conclusions in relation to therapy of neuropathic pain from the fact that a given compound would treat inflammatory pain. There was specific reference to the fact that NSAIDs, ibuprofen and so forth, would be jolly good for inflammatory pain. Anti-inflammatory is good for anti-inflammatory pain, but no good for peripheral neuropathic pain. So this was a field where prima facie the person skilled in the art was saying, well, look, these are actually different, these are really different areas that I'm concerned with. And so in that kind of context, to say, well, you can't just say because you could do the work for yourself that the patentee has done the work is again perfectly rational. It is not authority for the proposition that the presence of, or the ability to do simple confirmatory tests is irrelevant to whether or not a patentee has made a contribution or whether the patent should be regarded as plausible. So those are our core submissions in relation to Warner-Lambert, and they cover, I think, all of the key legal grounds of the of appeal. I will pick up briefly on the points on Agrevo as well. Before I do that, it's perhaps useful also just not because of the conclusions, but because of the analysis of the case law, just to draw my Lord's attention to the way in which Lord Mance summarised the effect of the case law in on sufficiency in his judgment, paragraph 194 to 195. That's at page 160 of the bundle, and he analyses the effect of the case law in the Board of Appeal slightly differently, in particular Ibsen, where I don't think I'm going to read out all of those points, but perhaps I could invite my lords to read those paragraphs on Ibsen and on Bristol-Myers Squibb, the Satinib case, which we respectfully commend in that context, and those are, in our submission, either supportive of, or at least not non-supportive of our submissions. And finally, on this point, just so that my lords see the divide, in 195, Lord Mance was saying of a second medical use patent that the approach taken by Lord Sumption to the positive requirements, I put it like that, of sufficiency by plausibility, were setting the test too high. He said that it puts the test too high to suggest that the specification must disclose some reason for the implied assertion of efficacy in the claim is true. Mounts on its face to, or certainly risks being held as a requirement. The plausibility of the claim must appear to be established prima facie through scientifically cogent reasoning or experimental evidence set out in the application. Admittedly, Lord Sumption goes on to suggest that the test is relatively undemanding, but he continues in paragraph 37 to say that it is sufficient in if the specification would cause the skilled person to think that there was a reasonable prospect that the assertion would prove to be true, and then that the reasonable prospect must be based on what the Board of Appeal in Salk called a direct effect on metabolic mechanism. And then he goes on, despite the use of phrases such as reasonable prospect and might well produce, there is a real risk that the test as described by Lord Sumption would amount to or be understood as involving a requirement to establish a prima facie case on the material contained in the specification. In my opinion, the authorities analysed above do not put the standard so high. They certainly reject speculative or wide-ranging unsubstantiated claims, but they accept as sufficient a tailored claim which appears scientifically possible, even though it cannot be said to be even prima facie established, without, for example, testing or assays according to the state of the art. Only if a person skilled in the art would have significant doubts about the workability of the invention would it in such a case fail for sufficiency of disclosure. Now that was said, albeit in dissent, in relation to a second medical use claim. We respectfully submit that there is really no basis for adopting a more stringent approach than, or whatever view one might take, than set out there in respect of a pharmaceutical patent claim. And that is supported, we respectfully submit, by two points that I'll go to briefly on the authorities. That it's not the law that it is invariably the case that in relation to a product claim, one needs to have what is described as a requirement to establish a prima facie case on the material contained in the specification in relation to the utility. Can I just show, my Lord, one case on this to which we refer in our skeleton, which is HGS in the Supreme Court, which is at tab 15 of the authorities bundle. So that is joint authorities 1. And the primary judgment given by Lord Neuberger, which was essentially seeking to reflect the policy, what he understood as the policy of the EPO in that context, starts at 109 of the report, but the part that I want to just draw my Lord's attention to starts at 96 and then goes on to 129.
Could you give a bundle reference?
Yes, I'm sorry, my Lord. It's page 395 in the bundle.
Thank you.
I apologise. You're working electronically. And the case there concerned essentially a new, something akin to a new pharmaceutical, Nutricline alpha, and its antibodies. It's a human protein. And the patent in question described the encoding nucleotide, the amino acid sequence, and antibodies of that protein, and it was that there were then objections to it. The key point of objection there was actually as a result of incapability of industrial application, but effectively the same approach was taken to that point as to sufficiency more generally. And one can take up the policy points in paragraph 96 on page 395, to which I've referred. There were submissions made in the Supreme Court from the Bioindustry Association in relation to the requirements of clarity and certainty. And it said, as its submissions also explain, after discovery of a naturally occurring molecule, particularly a protein and its encoding gene, a large amount of research development is required before there can be any therapeutic benefit. It's therefore important for bioscience companies to be able to decide at what stage to file for protection. And the Bioindustry Association were saying that it was reasonable to have protection at an early stage. They went on to say in paragraph 98, recorded as saying, funding research and development on the potential of therapeutic value of a newly discovered and characterized protein or its antibodies is dependent on the funders being reasonably confident the patent or patent application concerned will be reasonably safe from attack or likely to be granted. It's also relevant that bioscience companies attract investment by reference to their patent portfolios, which give rise to the need for certainty. The Supreme Court there drew attention to the fact that the purpose of the patent system to provide a temporary monopoly as an incentive to innovation, while at the same time facilitating the early dissemination of any such innovation through an application. It's true in any sector, it's particular force in the pharmaceutical field. And the Lord Neuberger went on in 101 to say the consequence of the undesirable consequences said to arise from the reasoning of the Court of Appeal and Mr. Justice Kitchen, on the basis that there will normally be a need to conduct tests to provide experimental data established at the standard they require that the protein or its antagonists have therapeutic use. This in turn is said to lead to two problems. First, such tests will or may involve clinical work, which would be hard to keep confidential. The tests would be expensive to run. Funding would be hard to obtain. And so essentially the policy approach, which was something that the court took into account, was that there was a reasonable basis for having patents of this kind, where the utility of them was not firmly established in the specification. Indeed, Mr. Justice Kitchen had referred to the patent in somewhat critical terms, and said at paragraph, or as he was reported as saying, paragraph 73 of the judgment, that he had concluded that there was nothing by way of experimental evidence to support the claims made, and the idea that neutrocrine alpha and its antagonists could be used to treat the extraordinary range of diseases identified as fanciful. Then said that in his view, a skilled person would come to the conclusion that the inventors had no idea as to the activity of neutrocrine alpha when drafting the patent, and that it taught the skilled person nothing useful about its activity other than neutrocrine alpha or is another member of the TNF ligand superfamily. So that was the basis upon which the judge, upheld by the Court of Appeal, said you can't have this patent. This is a speculative patent. If you read the patent, you would conclude that the inventors simply had no idea whether the relevant product, in that case the neutrocrine, had any utility at all for treating any of the relevant conditions. Nonetheless, and this was, in some senses, a sort of a pharmaceutical product patent, the Supreme Court said, well, that may be so, but we're not prepared to reject it on that basis as incapable of industrial application or insufficient. And the core of the reasoning was that they applied essentially what the Board of Appeal had said in relation to the patent, which is recorded in paragraph 107 of the judgment. And that was summarised as follows. First, the patent must disclose a practical application and some profitable use, so that the ensuing monopoly can be expected to lead to some commercial benefit. Concrete benefit, namely the invention's use in industrial practice, must be derivable directly from the specification, coupled with common general knowledge. Merely speculative use will not suffice. So a vague and speculative indication of possible objectives that might or might not be achievable will not do. Very remote from the present case, we respectfully submit. The patent and common general knowledge must enable the skilled person to reproduce and exploit the invention without undue burden or without having to carry out a research program. Again, very remote from the present case. In relation to apixaban, all you need to do is put it into a very short text.
But of course, we do have to be a little bit careful about this paragraph, because this is reciting the case law of the Boards of Appeal in Article 57.
You're right.
Whereas we are concerned in the present case with Article 56
no,
and Article 83.
My lord is absolutely right, and I hope I've made that point at the outset, that this was a case concerning industrial application, but in our respectful lack of industrial application, but in our respectful submission, the principles and the underlying rationale for striking a patent down are all consonant, and indeed that was a point that was made later on in discussing the extent to which the approach should be different under the insufficiency analysis that was also in issue. My point is not that this case is direct authority for the proposition that in the case of a new pharmaceutical, you adopt a fundamentally different approach, and then your lordships are bound by that. No, what it is an indication of, as we have said in our skeleton, is of the direction of travel of the law in this area, which is not to strike down patents, even where there is an element of work that needs to be done by others in demonstrating that in fact what they claim is true. So continuing on, where a patent discloses a new protein in its encoding gene, patent when taken with common general knowledge must demonstrate a real as opposed to a purely theoretical possibility of exploitation. Again, we say, well...
All right, but let's
so
put this to a test. One of the tests taken from the Article 57 case law, as Lord Neuberger recites in subparagraph 8, is that an, quote, educated guess is enough. Now, is it your submission that's enough in our context?
Well, that slightly depends on what one means by educated and guess, if I may put it like that. The answer is, in some contexts, yes. And the reason is this. A guess is something that may be said to be not based on specific evidence. But if it's educated, can one describe it as an educated guess that trains will be departing from Waterloo to Portsmouth? Yes, on one view you could say it's an educated guess. On the other view you'd say, well, actually that's substantiated. The description or the use of these kinds of terminologies is, one has to look at it as it applies in a given context. If a patent says, well, we have looked at this molecule or class of molecules, think it is efficacious, or likely to be efficacious for this range of diseases, for actually reasonable reasons, have actually done work to make them and test them. That is more, we respectfully submit, than an educated guess in relation to a disclosure. It is actually saying, well, there is a basis for saying that work has shown that would be a result. So my Lord is of course quite right to pick me up on the distinction between Article 57 and Article 56, and indeed a distinction between Article 56 and Article 83 and 84, none of which are exactly the same in the framework of European jurisprudence or United Kingdom jurisprudence.
But also the other point is that this is a prior decision of the Supreme Court to Warner Lambert.
Indeed.
If it's laying down a different standard, how does it help us?
No, I'm not suggesting that it is laying down a different standard or that it is directly applicable to your lordships. But what it does indicate is that insofar as it is said, Warner Lambert exhibits a policy which is applicable across the board for all kinds of inventions. And that policy should therefore be given effect across the board. It would come into conflict with this authority, which Warner Lambert doesn't say is wrong in any respect, which doesn't adopt that approach. Now, my lords, I accept that in some senses one is in policy terrain. All of the case law that you've seen, including SALT, including Exxon, all of the fundamental case law, in some senses, is about policy aspects. Because what it is doing is not taking just the framework of the narrow framework of the law, but is taking the purpose of the law and creating doctrines that give effect to the purpose. And that approach must be done by reference to a degree, the policy of what the law should achieve. And my submission is a relatively modest one in relation to HQS, which is that this court is entitled to take account of the fact that other cases of high authority have taken an approach, albeit on different principles, but with the same object in mind, that would not suggest that such a strict approach should be applied. So the final point on HQS, and again, I don't want to spend a lot of time reading out these paragraphs. My lords can, I think, read them for yourselves. The key point is in 107, because Lord Neuberger then comes back to that when he draws the threads together and his conclusions in paragraph 129. just before we go to that, Lord Newberger, of course, raises the precise question that my lords have both raised with me, namely, how do you draw these distinctions? Paragraphs 122 and 123, he says, I appreciate the dividing line between plausibility and educated guess as against speculation. As against speculation, just like the contrast between a real as opposed to purely theoretical possibility of exploitation can be difficult to discern in terms of language and application. This is a point on which tribunals could often differ. I might add that the notion that dividing line is not very satisfactory is illustrated by the fact that at one point in his evidence, one of the expert witnesses effectively equiparated speculation with educated guess. However, as a result of decisions discussed below, the board's approach to patents, such as in this case, is, I believe, tolerably clear. Now, my lord, that's not a exculpatory comment. Say, well, other judges also find it difficult to draw these distinctions. We accept that. We have done our best to try and assist you with material to draw these distinctions in the context of this specific set of provisions of law, even though they arise as well in other provisions. So finally, on Article 57, he allowed HUS's appeal on the issue, and he reached the conclusion by applying his understanding of the jurisprudence before to the facts found by Kitchen, Mr. Justice Kitchen. However, as I've stated in 105 above, there's good sense in the contrary conclusion reached by the judge in the Court of Appeal. I'd like to emphasise there's also good sense in the result, which, at least in my view, is mandated by the board's approach to the law in this field. And he says, just as it would be undesirable to let someone have a monopoly of a particular biological molecule too early, because it risks closing down competition, so it would be wrong to set the hurdle for patentability too high, essentially for the reasons advanced by the BIA and discussed in paragraphs 197 to 100 above. Quite where the line should be drawn in the light of commercial reality and the public interest can no doubt be a matter of difference of opinion. And in this case, apart from the fairly general submissions of the parties, not only submissions on such wider policy considerations. And so he reaches that conclusion, as did the other judges. There was some debate as to whether that was right, and Lord Hope accepted the proposition. Lord Walker had somewhat greater doubts about the approach, because essentially the Supreme Court was there differing from very experienced judges. Mr. Justice Kitchen and the Court of Appeal, that was a strong Court of Appeal, but nonetheless that was the direction of travel of the law in that context. The final case that I want to refer to is Agrivo, which probably it would be easiest to do completely after the short German, if that's convenient, or I can...
Very good. Shall we resume 5 minutes early? 5 to 2?
If that's convenient, I will.
Certainly.